Good evening. My name is David Rita. I'm co-president, along with Todd Ellman, wherever he is, of the Michigan chapter of the Federalist Society. On behalf of the chapter and on behalf of the entire student body, I'd like to welcome all of you here to the 8th Annual National Symposium of the Federalist Society. This year's symposium title, as you all know, is Property, the Founding, the Welfare State, and Beyond. I'd like to just, if I could say anything of a perfunctory nature, I'd like you to just make sure you check your schedules as the weekend progresses. There's a lot of events on the schedule, and a couple that even aren't on the schedule that we'll be notifying you about of a social nature that usually if you check near the registration desk, you'll see those. So it is also my pleasure to introduce someone who I think it's fair to say whose efforts help make this event possible. The Federalist Society, it's fair to say, has not always seen eye to eye on every issue with the dean. Some people would say we haven't seen eye to eye on any, but I think that's an overstatement. The fact of the matter is, those perceptions aside, without the efforts of Dean Bollinger and Dean Eklund, and in fact everyone associated with the law school, this event simply would not have taken place. And so, and I think the greatest proof of that right now is the fact that I'm about to introduce the dean himself. So without any further delay, Dean Bollinger.
It is my pleasure to welcome you to the law school and to Ann Arbor. As Janice Kelb said to me just a minute ago, I'm the closest thing to a host you've got. So I really am delighted to have you here. And if you need anything, there is a staff that will be ready to help you. I'd also like to say my own thanks to Todd Ellman and Janice Kelb, who came to me many months ago now and proposed doing this, and did it with a sophistication and an expertise and a maturity that I admired at the time, and I admire it more now. The first panel I am to just introduce, and all of these remarks should be very brief. I will close with saying that the first panel is the idea of property, and Mr. Tom Bethell is the moderator. Mr. Bethell is a columnist who writes for the American Spectator and the National Review.
Thank you very much. We're actually starting slightly early. We're going to cut out all of these long introductions, I think. But the idea of property, at any rate, is our subject. And the idea of property, just one thing I want to say right at the beginning, in case any of you had any doubts, is it's a big idea. I'm told that in law schools, when the subject is property, the students are taught tenants' rights. But things of that nature. I would just like to make the point that property, whatever it is, it's a very much larger idea than that. It's been said that the law and economics movement was an act of imperialism by economists who exported the idea of efficiency from economics into the legal realm. And in doing this, they were greatly liberated from their colleagues in the economics departments, and they were able to discuss such things as property, which had been taboo, has been, and in a sense still is, has been taboo for about 100 years in the economics departments. What I would like to suggest is what is needed now, today, is an act of reverse imperialism, where perhaps the legal profession should consider exporting a different idea, the idea of justice, into economics. And it seems to me that the idea of efficiency is somewhat inadequate in law, and the idea of justice is certainly needed in economics, and justice is intimately related to the idea of property. And in fact, what the relationship between what property and justice is, should be the grand study, the goal of studying law, it seems to me. But at any rate, with those very brief remarks, the first speaker we will be hearing from will be Professor Richard Epstein from the University of Chicago Law School.
There must be some form of divine interaction or spontaneous coordination between Tom, Bethell, and myself, because as I look back at my notes, I noticed that the first words that I had on them was property and imperialism. And the question that I was going to talk about, and indeed will still talk about, is how it is that we have to understand the system of property, and why it is once you start out with a good idea, which seems to be rather small, it continues to grow and to expand until it seems to take over the entire universe, leaving nothing else for anything else to do. One of the people who are knocked out to one side by this intruder, this property conception, is often justice itself. And in many ways, I think one of the essential questions for study is why it is when you have a full understanding of a system of property, it turns out that there may be no place for an independent conception of justice. So it turns out that Tom, Bethell, and I start from the same place, but I dare say we end intellectually in rather different places, although politically, again, we come together in yet another one of these odd twists and reversals that only political thinkers and lawyers can begin to understand. Now, the question is, well, what is this wonderful idea of private property, and why does it matter? And in order to deal with that particular question, if this were a long and exhaustive, we now have a nuisance problem, but that's also a property conception, which I was going to get to momentarily, and then been thrown off yes, an externality question. But I've lost my place, is that there are two distinct questions, one of which I'm going to systematically avoid for the moment, and the other that I will try to explicate. And the question that I'm going to try to avoid is the question of how it is that property rights are acquired, for which the general decentralized, individualistic answer that I usually light upon has to do with the first possession rule and all of its strengths and limitations. What I want to do is to talk about the second half of the particular problem, which is what is it that you acquire when you acquire a bundle of property rights in a particular thing? Now, part of the modern discussion of property rights in this particular connection has often been, I think, to implicitly degrade the intrinsic intellectual unity associated with the conception of property by arguing that what property is a bundle of rights, it's a bundle of sticks. And when you do that, you sort of get the impression that these sticks are hastily thrown together, that they don't all have quite the same length. It's almost a matter of random chance that they're next to one another and so forth. And rather what I want to suggest is that the bundle of property rights that are normally associated with the concept, far from being randomly and fortuitously put together, actually coheres and forms the basis of huge terrains of the ordinary common law. And let me first mention what those particular sticks in the bundle are, and then try to indicate to you exactly what the function of each of them is, and then invite you to speculate for a second what would happen if we decided to change the nature of our bundles and our configurations and to remove some from it. Well, the standard definitions of property, and these I think have very broad application, whether you talk in legal jargon, constitutional discourse, look at the Oxford Dictionary and so forth, tend to associate with a particular thing three rights. There's possession, there's use, and there's disposition. And in effect, it looks like a very nice kind of bundle. The first one says, in effect, that you're there and you could exclude everybody else in the world from doing something with your particular property, and it has the negative impulse. If we stopped with possession, however, it would turn out that what we did is we had a system of property rights which were equivalent to a blockade. It would mean that I could stop everybody else from doing something with the property that I own, but there would be nothing else that I could do with the property myself. So what would happen is that the world would be a tundra and I would have my own place on the particular checkerboard that was left to us. So in order to fill in the gaps, what one has is a system of use rights that are associated with property, so that it's more than blockade that it's at stake. It turns out that you get production as well. And typically speaking, it turns out that the only user of property is the fellow for whom exclusive possession turns out to be, and that person whom it's invested. Now, if you just stop with a system in which you have the right to exclude and the right to use, it turns out you then have to ask the following question. What happens if it turns out the value in use to somebody else is greater than the value in use to you? Is there any particular way in which we could arrange for some kind of a transaction to shift the use over from one person to another? And generally speaking, what happens is the entire area of gains from trade is made possible in both a social and an economic sense only if we include in property definitions the rights of disposition, by which I mean essentially the ability to sell, mortgage, lease, pledge, and so forth, various kinds of property, so that whatever endowments of rights were originally created can be corrected, modified, combined, and assimilated in one form or another through a series of voluntary transactions. Now, if in fact that turns out to be the bundle of rights, and you could run a system in which they're well defined, where you could identify boundaries, where you can make sure that voluntary transactions take place with people who are in a position to sell and people who are in a position to buy, it turns out that you should allow the system, as it were, to have this kind of self-generating capacity in which private, decentralized, voluntary acts enforced by a night watchman state will move you to a position where each change turns out to generate more by way of gains than it produces by way of losses, so that through its repetitive interaction, we move to higher and higher levels of social interaction, higher and higher levels of private gratification and satisfaction, without once, I might add, ever introducing an idea of justice to try to moderate or to connect the various transactions that take place from this particular base. Now, the one way that I think you can understand the power of the idea of property when you start from this particular foundation is to see in rather striking terms the various different branches of substantive law that are developed as we move incident by incident through the law of property and find out exactly what it entails. If you start with with the first of these incidents, possession, and exclusive possession, it becomes quickly clear at the moment that you examine the subject that property is not an individual conception, but at root it must be a social conception. And the social conception, I think, is fairly and accurately portrayed, not by what it is that I can do with respect to the thing in question, but who it is that I'm entitled to exclude by virtue of what takes place. And so it turns out that possession is exclusive possession against the rest of the world, and the entire law of trespass, as it tends to be organized, is essentially a body of law which is designed to vindicate exclusivity with respect to possession by given individuals. If, in fact, you start with that, then the next question you have to ask is, if you vindicate possession, what about the vindication of use? And the next body of common law doctrine turns out to be, in rather crude form, the law of nuisances, which is usually defined in its standard way as the ability of an individual owner to protect himself against non-trespassory invasions of his property, which impose various kinds of, and I will use the word with caution and explicate it later, unreasonable interferences with the uses in question. So that the body of nuisance law that we generally see coming out of the private law is essentially the tort responses against strangers with respect to the second of the incidents of property as it is generally conceived and created. When you look at disposition, it turns out that in many ways this, as an isolated incident of property, is one of the most elusive and difficult branches or incidents to protect. It is, of course, of enormous importance because, as I said to you before, the entire difference between value in exchange and value in use can only be protected and only be realized if there is some system of rights which makes sure that voluntary exchanges can take place not only between private parties, which is the office of the law of contract, but also without interference by third parties, which again is the office of the law of tort. And essentially, in protection of this particular incident of property, the way in which the system generally develops is in two directions simultaneously. And they're fairly old origin, even though they have lots of modern ramifications. The first of the incidents that one would talk about, or remedies, would be, in effect, interference with advantageous relations, which is the old case of Tarleton and Macaulay, where it turns out that if I wish to trade with the African natives, and my rival traders shoot guns between the two of us and they go back home, even though there's been no trespass upon my property, I can get the expectation from trade as against interference by force. And the second form of remedy that's normally associated with property under these circumstances is a much more modest remedy, but very important, it's defamation. And whereas many people have always been troubled by the fact that defamation seems to deal with intangibles, and yet simultaneously was introduced very early into the law, I think if you understand the structure of property rights, you'll see why defamation was essentially an earlier visitor to the common law camp. What happens is defamation doesn't protect reputation in the abstract. What it does is it protects advantageous relationships against interference by misrepresentation. So that the proper definition is the common law one, which says that if I make a false statement about a defendant to a third party so that he's no longer induced to trade with you, you can bring an action in order to recover for the loss of that particular interaction. So the general kind of prohibition against force and fraud normally associated with libertarian property theory accounts very nicely for the law of defamation. Now, in this very brief sketch, what you can do is take this particular stuff and account for huge portions of the standard common law doctrine simply on the question of what is property and how do we protect it against various forms of interferences by third parties. It turns out, however, there's an enormous set of weaknesses associated with this particular body of law, and the second half of the common law project of property is to figure out exactly what is wrong with this particular model as an effort to define a complete state of affairs as between private individuals. And here, let me just give you a few cases which start to throw the thin edge of the wedge, which leave people very uneasy about the system of property laws I've just described. Let's start with trespass. The first part of it is, suppose it turns out that you're on a public right-of-way and it's blocked by a heavy snowstorm, and the only way that you can get around that is to walk tiptoe on somebody else's land. Under these circumstances, are we going to describe that particular entrance as tortious? And more to the point, are we going to allow the owner of the property to block you from entry? And if you look closely at the law of property, as old as the doctrines of exclusive ownership are the various doctrines of necessity which allow the trespasses to take place. And it seems to me what you have to do is to find an explanation which explains why do you allow them to happen. If you look at the law of nuisance, you find the same thing. Categorically, any form of interference, however small, by way of noise, stench, smell, pollution, and the like, seems to be a tort. And if you took the standard hardline libertarian model, you would have to say that whenever there's an invasion of a right, you would have to have an injunction, just as exists in the trespass cases. And yet you can go back to the 19th century, certainly with Baron Bramwell, the sternest and archest libertarian who ever sat on any court, including you, Steve. He was the judge who developed all of the standard exceptions to the nuisance law associated with the live and let live doctrine and with the locality rule and so forth. If you go to the law of defamation, again, it turns out that whereas reputation is generally to be uncompromised, there is a mysterious body of privilege associated, for example, with the ability to obtain references about somebody who has not given your consent to the transaction and to act upon them, even though it turns out that they may be false and misrepresent the true state of affairs. The question you have to ask, therefore, is not how you explain the basic principles, but how it is you manage to have a system of property rules to cohere with a system of exceptions based upon various kinds of necessity transactions. And I think in this particular area, the great modern advance based essentially on transactions cost economics shows the unity of all three cases. Essentially what happens is that the basic area of property works best in those circumstances where exclusive rights given to any individuals, by virtue of decentralization, creates worlds in which bargains take place with a minimum of confusion and strategic behavior. It turns out, however, that under certain localized circumstances, giving these absolute rights to exclude does not advance competition in ordinary markets, but rather creates bilateral monopoly and holdout problems and transactions cost obstacles of one sort and another. And what happens at common law is that we see various kinds of situations in which there's a systematic, intuitive willingness to back off the comprehensive ideal of property in favor of a system which is a little bit frayed at the edges, which in essence, if applied systematically, works to the advantage of all individuals who are required to relinquish the property rights that they possess. Now, once you understand that, it turns out that property at the common law libertarian mode becomes a first approximation for a much more complicated state of affairs. And to be just sort of minutely technical for a second, what happens is virtually every one of the common law exceptions that I've given can, I think, be defended on the ground that they produce a distribution of rights which is Pareto superior to the one that it displaced, in the sense that ex ante there are no losers from the transactions in question, so that you're able to explain why it is you don't believe in a system of hard libertarian property rights without committing yourself either to interpersonal comparisons of utility or to massive systems of government intervention. What is striking, and this is the point that I'll leave you with since I have, about 3 more minutes? 2 more minutes, is the following kind of dilemma. When I work in takings and eminent domain, essentially the way in which I conceive that particular enterprise is to take this particular conception of property and to go public with it. To ask what happens when the interactions are not between two people at the side of the road, or two people who are noisy, or people who are giving privileges with respect, or references with respect to prospective employees, but rather when you're talking about massive systems of regulation having to do with air pollution and with common pool problems in oil and gas and with bankruptcy and with labor relations and so forth, taxation. And it seems to me that what I would urge is that the same model of intellectual development that takes place within the private law is in effect the proper mode of allocation with respect to the public law system that comes to replace it. And it therefore turns out that when you look at the way in which the Supreme Court, for example, talks about property, it is no accident that in an effort to create a very large welfare state, it eviscerates the institution of property incident by incident, so that the right to exclusive possession can be easily overridden, in many cases on fairly feeble showings of police power justifications, often very badly articulated. The idea that, generally speaking, you're allowed to use your property to the limits, save only with the live and let live exceptions, is now replaced by a law of zoning which says so long as we allow you to do anything, we can prohibit you from doing everything else with respect to the property. And if you look at various kinds of cases having to do with rights of disposition, whether you're talking about prohibitions against the sale of eagle feathers or rent control or price controls or wage controls and so forth, you will discover systematically the right of disposition is constantly compromised. And it seems to me that what's happened is that the reason for public disarray is that we have managed to eviscerate property in its public setting. And what we need to do is to have a system which recognizes that the grand idea of property and the limitations associated with it in the private law have much more staying power in the public arena. Thank you.
Professor Ellen Paul is unwell and cannot be with us tonight, but her husband, Jeffrey Paul, is here, and he will be, as I understand it, reading some remarks that she would have delivered. Professor Paul is professor of philosophy at Bowling Green State University, and I think I'm right in saying that you share the views of your wife, but you perhaps not entirely comfortable about taking questions afterwards.
Yeah, I think that's fair. Maybe we could phone her in as a respondent from her sick bed. Yes, I'll be reading her remarks. The proposition that I wish to explore here is that property rights are most secure when grounded in a natural rights foundation. Of course, in the 10 minutes provided to me, deducing a philosophical defense of property rights would be impossible. But I have attempted it elsewhere in a book entitled Property Rights in Eminent Domain. What I propose to do now is something far less ambitious, to discuss an example which is intended to illustrate why a natural rights approach to property ought to be appealing to those who appreciate the importance of property to individual liberty. I will try to show how this rights approach is superior to two other philosophical stances that enjoy much currency today: utilitarianism and Paretianism. Of course, in the present company, this example could be drawn from nowhere else but an actual case. The case I have in mind is Moore versus Regents of the University of California, decided by the California Court of Appeals for the Second District in July 1988. As the court stated, Mr. Moore's appeal raised, quote, fundamental questions concerning a patient's right to the control of his or her own body, unquote. In 1976, Moore sought treatment at the UCLA Medical Center for a condition diagnosed as hairy cell leukemia. His spleen was removed. Two researchers at the center had determined prior to the removal of the diseased organ that Moore's cells had unique properties, and they arranged to have the spleen delivered to them. From his spleen, the researchers developed, using the techniques of genetic engineering, a cell line, quote, capable of producing pharmaceutical products of enormous therapeutic and commercial value, unquote. The regents, Dr. Gold, and his assistant, Kwan, then patented this cell line and methods for producing drugs from it. In addition, they contracted with 2 biotechnology companies to commercially exploit this patent, for which they received generous remuneration. Moore cited the defendant's statement that by the year 1990, the commercial potential of these products would be approximately $3 billion. Further, he claimed that without informing him of their purposes, the appellees continued to extract tissue samples from him, including blood, blood serum, skin, bone, marrow aspirate, and sperm for almost 7 years. These extractions were represented to him as being for his own welfare. The trial court had rejected Moore's complaint and sustained a demurrer by the defendants. The trial court's position was that Moore had failed to state a legitimate cause of action for conversion. They found spurious his contention that his tissues and the cell lines derived from them constituted his personal property. The appeals court, however, thought otherwise. The majority eventually answered in the affirmative a question it posed for itself at the outset, quote, whether the commercial exploitation of a patient's cells by medical care providers without the patient's consent gives rise to an action for damages, unquote. The court reached this conclusion on implicitly natural rights grounds. Surely, if the decision had been written 200 years ago, the court would have explicitly articulated a natural rights, natural law approach, and the matter would have been settled with little fuss. As this court was sitting in 1988, after a good half century of, quote, bundle of sticks thinking about property rights, no such explicit approach would have been conceivable. Instead, the court pondered whether it should give the patient that right. A natural law jurist would have sought to find the law. The difference is subtle, but important. As the court stated, conversion is a strict liability tort, dependent neither on the knowledge nor the intent of the defendant. To state a cause of action for conversion, the plaintiff must allege, 1, that he owned or had a right to possess the property at the time of conversion, 2, that the defendant did convert his property by a wrongful act, and 3, that he suffered damages thereby. The conversion occurs without the owner's, quote, consent and without lawful justification, unquote. The court concluded that, indeed, the plaintiff had stated a cause of action for conversion. The court's reasoning in reaching this conclusion is a bit of a muddle from a philosophical perspective. Many times it resonates with phrases that our founders would have found congenial, such as, quote, there is a dramatic difference between having property rights in one's own body and being the property of another, unquote. Yet in the very next sentences, it treats the issue of property in one's own body as one that could have been, but was not, settled by the legislature, and upon which some future legislature might deign to speak. However, given this legislative lacuna, the court did proceed to determine the issue much in the manner that a natural rights jurist would have proceeded, by defining the term property, reasoning by analogy from things that the law definitely does consider property, to this novel issue of cell lines, and citing cases that dealt with the ownership of bodily wastes, body parts, and the right to refuse medical care. From the cases examined, the court concluded that, indeed, the right of dominion over one's body, the right to exclude others from using it, and the right to dispose of it have been legally recognized, even though these rights may be subject to limitations, and the court mentioned public health as one rationale. This does not negate the property right in one's own person. The court found ironic the defendant's claim that they could have property in Moore's cells, but he could not. They found suspect also claims of a utilitarian nature by the California regents that if such a right were recognized, medical research and public health would suffer. Fundamental rights cannot be overridden, quote, absent legal authority, unquote. while a pure natural rights jurist would have said something even more emphatic, that fundamental rights cannot be overridden even by legislatures, the majority went just about as far as a contemporary court could have. A natural rights approach, then, recognizes a property right in one's own person. In this case, such a recognition leads directly to the conclusion that if Moore can prove at trial that he did not consent to the use to which the defendants put his bodily substances, then he should prevail on the conversion complaint. Extending such reasoning, it is easy to show how a rights jurist might apply such reasoning to zoning or urban renewal via eminent domain. The taking for urban renewal would be seen as a violation of the owner's property rights, an illegitimate taking from A to enrich B. Zoning would be viewed as an illegitimate limitation on an owner's right to use his property as he sees fit. Now, how might a utilitarian jurist view Moore? It just so happens that the dissenting judge in Moore employed precisely such reasoning. And he did so to reach the conclusion that the plaintiff had not stated a cause of action for conversion. He argued that discarded body parts and substances are not property, that even if they were, the plaintiff had abandoned them, and that Moore could not have suffered any damage from the defendant's research and commercialization of his diseased organ. But what seemed to weigh most heavily in his dissent was a sense that if body fluids and parts are recognized as property, a market will arise. Women will sell their fetuses and others their vital organs. Medical research will suffer, while shops trafficking in used body parts will proliferate. For good measure, he waved the AIDS banner. If patients have the right to forbid use of their discarded tissues or hold out for the highest bidder, then research to fight this killer will be stymied. The legislature ought to resolve these issues by balancing, quote, the vital competing interests of the patient, the health care provider, the commercial research laboratory, and the public at large, unquote. A utilitarian loves to balance competing interests, to maximize social welfare, to lump together the incommensurable interests of individuals in order to arrive at the common good. What he abhors is the notion of fundamental rights of individuals that trump considerations of expediency or the supposed public good. For a utilitarian, Moore would be easily dispatched. Great public benefit arises from scientific research derived from the discarded, even diseased body parts. So Moore has no claim on conversion, that is, no property right, no illegitimate taking of property, no damages, hence no conversion. Here we have a vivid example of natural rights and utilitarianism leading to diametrically opposite conclusions on a fundamental property issue, self-ownership. Where might a Paretian stand on the issue raised by Moore? Pareto standards have proliferated in recent years, but the original idea was to provide an efficiency standard for government policy making, particularly welfare policy, that would avoid utilitarianism's disregard for individuals in agglomerating the greatest good for the greatest number. A rearrangement of resources is Pareto superior to the status quo if no one is harmed by the change and at least one person is better off. A newer version of this standard that has gained adherents, Richard Posner for one, is Calder-Hicks, which avoids the rigor of Pareto superiority or Pareto optimality by defining a reallocation of resources as efficient if it enables the gainers to compensate the losers, whether or not they actually do so. Glossing over technicalities, it is clear that on any of the Paretian standards, Mr. Moore would fare rather poorly. To begin with, lots of people will be better off as a result of the pharmaceuticals developed from Moore's cell line. The researchers themselves, the university, and the drug companies, saying nothing of patients whose lives will be enhanced or even saved. Was anyone harmed? Mr. Moore's spleen was diseased, and he wanted it removed. No harm there. Was he made worse off by the follow-up extractions of bodily substances? This might be debatable, but presumably there was some therapeutic benefit from the procedures in detecting whether any cancer cells had migrated to other organs of his body. But even if he had been harmed, Calder-Hicks comes to the rescue, for he could have been compensated for any slight harm with still a huge surplus left over for the gainers. Of course, compensation need not be paid to him to meet Calder-Hicks. to meet the Calder-Hicks-Posnerian standard. What we have witnessed then is the failure of two competitors to natural rights, utilitarianism and Paretianism, to protect something as fundamental to the defense of property rights as the right to use, dispose of, and exclude others from one's own body. Does this not make one hunger for a good, solid philosophical defense of natural rights?
Our next speaker will be Professor Carol Rose, who is a professor of law at Northwestern University, and she has also taught law at Stanford, Berkeley, Chicago, and Yale.
It's a kind of a commonplace that there isn't any one kind of property as such. But I think it is fair to say that there's a common condition for property, and that condition is scarcity or competition. Nobody really thinks that much about property rights except in conditions of scarcity. When there's a lot of stuff to go around, you don't care that much about who has the right to what. And what that suggests, it seems to me, is that what a property regime is there for in some way is to mediate conflicts among people. The point of that is that a property regime is in a way a kind of a social product. A regulatory regime, as some say, because the design of it or the intent of it is to do something about the conflicts that might occur between people if there were no entitlements. Now, that doesn't mean that a property regime is necessarily a governmental product, before I hear too many sharp intakes of breath. Because as a number of people have pointed out, including Bob Ellickson, who's here in the audience, a lot of what we think of as property, or we have a lot of informal property systems that are based on something like tacit agreements, custom, culture, and so forth. I can give it as an example, the neighborhood where I live in Chicago. When it snows and you shovel out the space in front of your building and you put a kitchen chair out there, nobody else is going to park in your space. It's your space. Now, of course, this is not legal. There aren't any legal rights in the parking places in front of your house. But there is that understanding that it's your parking place. Everyone can come up with a lot of these places in line at the movies and so forth. And the point that I want to make is that property is a kind of a social product because it depends on the recognition of others. And that further point is that if there is an idea of property, a lot of that idea is going to hinge on what the social group, at least implicitly, is trying to accomplish. Now, my own view about this is that historically, in our Western society, there have been two major ways to answer that question: what's a property regime trying to accomplish? What I want to do is to describe those positions very briefly, and then what I want to try to do, although I feel somewhat uncertain about this, what I want to try to do is to position a libertarian view with respect to those other two. Those other two dominating views, I want to say, also are coercive systems. I think the difference with the libertarian system is that it is not the libertarian understanding of property. Let me begin briefly with a discussion of what I regard as the really dominating view, at least in our society. It's the one that I think is really Richard Epstein's. And that's the idea that a property regime is aimed at something like preference satisfaction or utility maximization. Now, I know he's not going to agree, but let me run through it. Here's why. And I think Richard would agree with this. The idea is that a property regime doesn't just divvy up the goodies or slice up the pie. What it does is make the pie bigger. How does a property regime make the pie bigger? Well, it does a number of things. First of all, it reduces conflicts. So we don't waste a lot of time fighting about who gets what. And that makes us richer. That makes the pie bigger. Second thing it does is it encourages investment. We feel secure in our little slice of whatever we've got. We make investments. That makes what we've got more productive, and that makes the pie bigger. And finally, property rights, if they're well drawn, allow trade. And we get the gains from trade that Richard mentioned. So that the upshot of all of this is that a property regime is going to maximize preference satisfaction by increasing the size of the pie. There's more there, so more preferences can get satisfied. Now, here come the problems. Richard mentioned the problems of transaction costs. Sometimes this occurs that people can't really get together to trade. And what happens then? Well, our law diverges from consensual transactions in those scenarios where the transaction costs are too high. And that's one place where something like coercion comes into our system. And it would be compatible with a system that sees the function of property as satisfying preferences. Here's another. There may be some resources that have economies of scale, and because of that, it seems like they're best managed jointly. And in a well-oiled property machine, those resources are going to wind up as family property, perhaps, or corporate property, or the property of some larger informal group, or possibly the property of a municipality or a state or even the nation. Now, the need for that joint ownership is one of the classic reasons for a coercive element in a preference-maximizing property regime, and Ms. Paul's comments mentioned that. That's eminent domain, a forced sale of private property for public use. Sure, you get fair market value, but nevertheless, your property is taken against your will. The justification for that coercive element is that ex ante, we might prefer to be in a system that had eminent domain rather than being in a system that doesn't, because we want to be able to use a road system and not have somebody hold out on us and not let us get through to San Francisco or wherever we're going. The preference maximizing view of property might have some other coercive elements as well. And some of these are even more controversial, but let me give you an example. Redistribution. It's at least possible to justify redistribution, taking from the rich and giving to the poor, on a preference satisfaction ground, if one thinks that there's a diminishing marginal utility of wealth. That is to say, that the dollar in the hands of the poor person is worth more, gets more preference satisfaction than the dollar in the hands of a wealthy person. Again, of course, that's quite controversial, but it's not altogether implausible. A number of 19th century economists thought so, like Alfred Marshall, for example. If it were true, if we could make up a plausible case for that declining marginal utility of wealth, we could make transfers from the rich to the poor, and we could maximize preference satisfaction that way, since the poor get more satisfaction out of their out of the same resources, basically. And again, supposedly the justification for that would be that people would agree to that system ex ante before any of us got into it in the first place. On the other hand, there's a constraint on that constraint. We don't want to take so much away from the rich people that they get discouraged from investing, and then which would make the total pie smaller, and we don't want to make the total pie shrink more than is warranted by the incremental satisfactions that the poor get from having some redistribution in their direction. Now that, of course, ties in with takings doctrine. If the rich, or in fact anybody else, get their earnings taken or their property taken and they get discouraged, then ultimately they quit working. Well, we don't want them to quit working. We don't want them to get that discouraged, because that would reduce the total pie. So we have a sort of an insurance policy, and that's takings compensation. All I'm trying to point out is that it's fairly easy to see that there are coercive elements, or there could be coercive elements in a property regime based on preference maximization. And I believe that's what Ms. Paul's paper is directed at, that those coercive elements are there in a kind of a utilitarian view about property. I would see those coercive elements not as constraints on a preference-satisfying view of property, but rather as part of that same property universe, because the coercive elements are ways that we get more preferences satisfied because they maximize the pie. Now, there's a lot of criticism that can be made of that version of that picture, that preference-satisfying picture of what property is for, and particularly, I think they run to the notion that you can compare different people's utilities. I want to draw a contrast with a completely different property regime, and it's one that's based on a different version of what property is good for. It's one that, if anything, is considerably more coercive than a property regime based on a preference satisfaction, but it's one that was around for a very long time. What's the purpose of property under this second and really much older property regime? Well, the purpose of property under that a quite older view of property is that property is supposed to accord to each person what is appropriate or proper to him or her. And what is proper is that which is needed to keep good order in the commonwealth of the body politic. Very standard version of property from the Middle Ages up to the 17th and 18th centuries. An example. There's monarchist writer Jean Baudin, the late 16th century. He saw property as a restraint on monarchic power, although this guy was a monarchist. But he said, no, we've got to have property for the maintenance of families. Why do we have to have families? Well, we have to have families because they, in turn, are necessary for the maintenance of the Commonwealth. They're little sub-rulers, actually. This version of property didn't really see property as all of one kind. Property not being fungible or purchasable by money, even. But rather, different kinds of property went with different kinds of roles. The family property that Baudin was talking about was land, particularly, and not just any old land. Land went with the specific families that were associated with that specific land. Land of any kind, of course, was associated with males. Females generally could, landed property could be passed through females in a way, but they didn't control it at all. The only property they really had was in money, movables, transient things, and in fact, in a way, females were like money. They were transient, subjects to family trades among men. So this version of property is that property is what is proper or appropriate to a given individual or a given entity or group, and that normally means that property is what's proper for one to do one's part in keeping good order, and the good order is normally a hierarchy. The king had royal domains, for example, and the theory did not need to tax anybody because the income from the domains would provide what was necessary for his overarching governmental functions. The nobility, in turn, had their own lands on which they were sub-rulers, and they needed that property in order to support them in their kind of sub-ruling role. Same for municipal corporations. They had their own endowments, and by managing those endowments, they could have the income that would provide them what was necessary for ruling. By the way, New York City had its own endowment, and Dirk Hartog has written a quite interesting book about what happened to that when we started to change our view about rule and sub-rule. You've seen the same association of property with rule in the older pattern of chartered monopolies. Shoe manufacturers, textile manufacturers, all the rest of those guild guys, they got property, monopolies in certain kinds of commercial enterprises, and in exchange they were supposed to keep the enterprise in good order. Same with the proprietors of the colonies here. In theory, if the royal endowments couldn't cover royal expenditures, the kings were supposed to ask the subjects for subsidies. They couldn't just take the subjects' property. The reason for that, it wasn't because the subjects were going to get discouraged. The reason was the subjects' property was proper to them. They had to have it to take their place in the body politic, to exercise their control over the part of the body politic that they were particularly responsible for. There's an American version of this too, and it was around until at least the Civil War. It's now kind of all the rage. Civic Republicanism, some of you have probably seen some things about that. The Republican version of property wasn't as hierarchical as the monarchic understanding of property in this sense of property as propriety. There was a good reason for that. In a republic, citizens were supposed to rule themselves. And in order to rule themselves, they needed property. Why? They needed to be independent in order to be able to deliberate and then use their deliberations for self-rule. Now, with a couple of things about that Republican property, and the first thing to note about it was that in a republic, not everybody was a citizen in this older understanding. There was a lot of talk, for example, about Republican independence among the backcountry slaveholders in South Carolina before the Civil War, and it would never have occurred to anybody that everyone was supposed to have property because they were all supposed to be citizens. The citizens were just the heads of the household. Another thing to note about that Republican version of property is that, as in monarchic versions, not all property was alike. The property that really counted was landed property. Jefferson's agriculturalism in some ways wasn't that different from a medieval view, that land was the genuine article and money was merely transient, dependent, effeminate, unsturdy. And finally, this vision of property was more or less indifferent to encouraging accumulation and maximizing wealth or preference satisfaction. Property was associated with governance and good order, but that included a duty to liberality, to assist in alleviating the distress of those who were in need. Poor relief was understood to be kind of a duty. It really wasn't until the 19th century we started to worry systematically about the bad incentives that generosity might induce in those who were the recipients. Now, all of that seems pretty antiquarian, and indeed it is quite antiquarian. But I think there are some echoes of that in modern legal thinking, and here are some examples. I have a suspicion that a part of the motivation of our welfare laws is based on the sense that poverty is a kind of a disorder. People ought to have enough so that they can avoid that disorder, which brings scandal and disgrace to our community. As to takings law, I see some of these arguments in taking stuff too, and they're the kinds of arguments that drive Richard crazy. The first one doesn't. The first place that I notice is in the test of physical invasion. You look at the rhetoric of those things sometimes, and you'll see this version of property as propriety coming through. A physical invasion is a sort of an affront to the owner. It's a violation of good order in our system. But the one that does drive Richard crazy is one of the diminution in value arguments. One of those tests is whether the property after regulation can produce a reasonable income. The underlying idea there is that an owner doesn't need more than a decent income from property. That's all you need from property. That's all your property entitles you to. It's decency and good order is what's important. Now let me sum all this up and say a couple of words about where I think property arguments or libertarian property arguments might fit into all of this. Please bear with me because I'm not as familiar with those kinds of arguments. First of all, the older property as propriety idea, I think, is really quite coercive, perhaps coming from a really sort of desperate desire for order in a rather disorderly time. And that regime looks at property as an institution that fosters the right ordering of entitlements in the world. The preference maximizing view, coming later in time, gives up on the notion of a right ordering of property, or as any property as being proper to different kinds of roles. Property is more or less fungible. What it does do is retain some coercive elements. Not anywhere near as coercive as the older view, but there's still some coercion in there. Now let me make a few surmises. It seems to me that there are clearly a lot of overlapping features between libertarian property views and the utilitarian ones. And I think Richard's position in some ways shows that too. Particularly in that both libertarian views and utilitarian views have a large role for quite sharply defined property rights, though perhaps for different reasons. As I understand the libertarian arguments, though, those arguments would not be willing to go along with the coercive aspects that are involved in preference maximization as a property regime, any more than they would go along with the coercive aspects of the older property as propriety. What I wonder, though, is whether the libertarian position might in fact be kind of closer to the older property as propriety understanding, at least insofar as the libertarian position argues that property rights are simply right without respect to utilitarian consequences. And I wonder if that isn't closer to an older idea that would go something like the following. In a well-ordered society, it's right that people have their own space, govern their own affairs, manage their own bodily integrity. Now, I don't mean to suggest at all that the libertarian view of property has the enormous paternalistic baggage of the older understanding of property as propriety. It seems to me that libertarians are vastly more optimistic about our human ability to order our own affairs without disciplining force. It seems to me that the libertarian attitude about property or attention to rights is only like the older view insofar as it shares with that older view some notion that entitlements, certain kinds of entitlements, are proper to human beings. The difference, of course, is that the libertarian thinks that we can do that without resorting to coercion. Now, what that suggests to me is that a libertarian property regime has to be a cooperative one. And this brings me back to the beginning. I would guess that if libertarians are really serious about property, one of the major issues in libertarian property would have to do with cooperation and the means of arriving at cooperation in recognition and maintenance of property rights. Now, I don't regard this as at all hopeless. It seems to me there are a lot of examples of property rights that are based on cooperation without coercion. And I would suggest that if you're interested in seeing some of these, that you start with Bob Ellickson's article on Shasta County and on the management of livestock under a kind of a cooperative regime that's based on custom. That's as much as I want to.
Thank you very much. Professor William Miller is a member of the law faculty at the University of Michigan, and we will be hearing from him now.
One of the problems of going last is you get preempted from some of your best lines, but I'll try and make do. Let me tell you a little bit about my background. One is I was trained as a philologist, so-called a lover of words. That is, a historical linguist. I've shifted hats a little bit, and now I'm a social historian and teach blood feuds in the law school, concentrating on the dispute processing techniques and mechanisms of stateless societies, primarily Viking Iceland. What I'm going to, I know it always gets laughs. Tonight I'm going to go back to my prior life, which is as a historical linguist, and talk about a tale of two words. One of them is property. The other might offend you, so I'm going to postpone it. But nevertheless is intimately linked with property. I withhold it until it fits in properly, and Carol has already preempted me on proper and properly and propriety, but you'll see a little more of it in what's to come. In the meantime, you can think about how to fill in the blank on the other side of the copula is. Property is blank, and now I'll go on. Property, the word, came into English with the Norman invaders. An Anglo-French form was ultimately derived from the Latin adjective proprius, meaning own, proper, special. Property was what was proper, one's own, that which was proper to oneself, characteristic of oneself. In English, the sense of proper and properly quickly came to take on positive values. It was what was fit, what was apt, what was suitable, even what was correct. It was also that which was inherent or intrinsic or essential. It was more than just what belonged to oneself. It was oneself, much in the manner that we say it is proper, or is the property of neon to be inert, or being inert is proper to neon. Now, the word property also participated in this positive evaluation that attended the development of the word proper. But it is a little harder to see with the word property. The word property received positive evaluation from its intimate connection to the word proper, but also from what happened to the related word propriety. Propriety, you see, was a biform of property. Like some of us say either or either. Some of us say roof or roof, root or root. I happen to say roof and root, coming from Green Bay, Wisconsin. Burst or bust, curse or cuss. By the way, we probably know, all of us will recognize root and root, roof and roof as biforms, but very few of us will recognize curse and cuss, burst and bust as biforms. Actually, what they are is two different dialect versions from different medieval English dialects. But notice they both come into modern English with slightly different valorizations. One's proper, one's called improper, but they're just from two different dialects in about 1300. Propriety was simply, this gets back to propriety and property, believe it or not. Propriety was simply what the non-Norman medieval French person said when Normans said property. So a Norman would say the medieval version of propriété, and somebody from the Picard would say propriété. In other words, the word property was appropriated into English twice, once from the Norman dialect and once from the Picard. This is not uncommon linguistic practice, and you might compare the English biforms channel and canal, both of which were just adopted from different French dialects at roughly the same time, but they meant the same word in that French thing in that French dialect, but take on different meanings in English because there's no point having two different pronunciations for the same word. Cattle and chattel is another one. You can think of all kinds of variations of this, one coming from northern dialects, bleak and bleach, for instance, being the same word originally in Old English. The semantic histories of propriety and proper show more directly and explicitly something that also happened with the sense of the word property. There is an ideology and argument in our words, and none of us, I think, will dispute that. Consider the quiet trick that the sense of the word property as something inherent, as something essential, does to the sense of property as a thing possessed or owned. The ideology of the word is to disguise a movement of things from the outside to the self by denying that there was a movement in the first place. It glosses over appropriation and expropriation by claiming that there never was such a movement from outside to inside. Property, hell, that's just being ourselves. It's us, just like our minds and our teeth and our body parts, our sperm and whatnot. Owning is little more than the self-fulfillment of an organism in the same way that sexual maturation is. It's just the natural order of things. Objects aren't appropriated, other people aren't even involved. There's just a natural extension of one's very own personhood. What the words property, proper, and propriety do then is collude to deny some rather nasty social facts about acquisition and retention of things once acquired. It's kind of interesting in this regard to compare the contrary history of the Germanic word, the word that meant to possess and to have at the time that the Normans reached the English shores. The predecessor of modern English to O. In Old English, it was agen. And this is what, when we said, it is the word that became modern English to O. But it's what meant in Old English to have, to possess, to have as property. O, interestingly enough, originally meant to possess, but ended up meaning virtually its opposite, as all of you can fill in right now. O, the verb to O, in its Old English form, originally indicated a movement from out to in. That is the moment of acquisition. Like property, but sometime in the early Middle English period, it was already starting to indicate the reverse movement from the self outward, i.e. in the modern sense of to owe, that is to pay someone back. Now the shift of sense of O left a small lexical vacuum about 1300. Once O started to mean what it did now, there was no verb around to mean to have, to possess in the particular form of ownership. Now we see what happens is entered the modern version, the medieval version of the modern word to own, which originally meant more specifically to seize, to grasp. It's kind of interesting that the language of the conqueror, the French language, gives us the word that disguises the very act of conquest, but indicates it at the same time, that is, property. And as indeed the strange history of to own does also, from seize to ownership. And that the language of the conquered, the poor Anglo-Saxon, for owning property ends up reversing much of its sense. Within a century or two of the conquest, Old English O, agen, ends up meaning giving up, not taking in. Now all this brings me around to another matter. The second word that I promised you. Property demands an object universe that we can appropriate to ourselves, in spite of the word's implied argument that there need be no object universe at all, just the plain old extension of our proper selves. But that's all ideology. We all know we need objects, and a world of objects or property, or any discussion of it would be an utter waste of time. And that brings me at long last to excrement. For it is here that we find the first object to appropriate. And I'm serious. Let me treat you to the etymology, a word history of the good old Anglo-Saxon four-letter word shit. Shit is an ancient word. It took me a whole PhD to learn this. It is Indo-European in its origin. And when we ever find a Indo-European root, we always put an asterisk up against it because we don't know who these Indo-Europeans were. What they were the people who we think they're roaming around the Russian steppes about 4000 BC speaking in asterisks. Because they didn't have tape recorders. But this is what we can reconstruct by taking all the modern languages and their various dialects, from Russian, Lithuanian, from English and all the other Germanic languages, from Latin and Greek, and taking them back and figuring what had to be the original root to produce all the modern variants. This is the one that could account for shit. See if you can figure out the root sense of Indo-European ske if you find out that Latin scire, to know, science, is from the same root. Conscience, and every other Latin version of scire, the Latin verb to know. All your hostility toward your teachers now kind of coalesces. Greek schizo, schizophrenic, schizoid, schism. Old Irish skion, and I don't expect anybody to know that. The Irish word for, unless you're a medievalist like I am, you know that Irish scan means knife. Old Norse, which is my specialty, Old Norse ski, Old Norse skit, which is Old Norse version of the unnameable, English shin and skin, all go back to the same root. So Can somebody shout out what the key underlying concept was in Indo-European? It's about separation. It's about splitting. The concept is originally cutting. Knowledge means making distinctions. It means having more than one thing. Because if you have only one thing, you can't talk about anything. It means comparisons. And it means in the world of cutting branches off of trees, of carving off a ski in Old Norse. And it means, in the psychology of the infant, of the human infant, it means the first awareness of otherness, the first awareness of something outside ourselves. It means quite literally that shit is the primal object. It is the first thing that is out there, the first thing we perceive as other. How do we know it's out there? We saw it come from us. We saw it split off like skis, like distinctions, like knowledge. Before we can have property to appropriate, we need things out there to grab, and unfortunately, excrement is it. I'm not making this up. What distinguishes, let me be a little Freudian for a second, what distinguishes the anal from the oral stage of infantile sexual development is that in the oral stage, this has actually been the one part of Freudian psychology that has been confirmed in empirical studies, laboratory studies, is that the oral stage, there's no object perception. The little kid sees the mother's breast, and the mother's breast is the child. It doesn't discern object. It's the universe as subject. The mother is merely the child's very own extension. Comes the anal stage, and the object is at last perceived, and the first object perceived is excrement. Those of you who have children, who obsess with it, make gifts of it, refuse to let it go, or let it go when it pleases them, know that children invest as much psychic energy in their bowels and their production as their parents, anxious to potty train them, do. If property then represents the movement from object to subject, of outer to inner, defecation is its converse, and more important, its enabling condition. For it is the production, defecation, that produces the objects we appropriate. Without it, there's no property. Now, let me just step back a second and think, you think I'm making this up? Christianity and much of Western culture for at least the last 900 years that I have special knowledge of has always equated money with excrement. Filthy lucre was, and if you've ever seen medieval paintings of hell, you'll always notice that the misers and people guilty of avarice are analyzing Satan's shit. That's their punishment. The miser is always depicted as playing with feces. At some profound psychological level, our ancestors and our innermost beings know that what I'm saying is true. Those of you who've read Gulliver's Travels, I'm cut. Our mutual friend know that there's a long literate tradition about this. Sorry, I'm done.
Sure. Yeah, we'll go straight to any exchange or views that Professor Epstein, do you have any?
Yeah, of course, I didn't have views on it. Well, I mean, actually, yeah, I want to comment very briefly on the three papers. Let me first comment on Ellen's paper, although she's not here to defend herself, and explain why it is I think that the convergence between the natural rights and the Parisian strand of the consequentialist tradition is stronger than she stated. The way I would want you to understand the Moore case is essentially as a problem of legal transition, given the facts of a first-time only kind of phenomenon. That is, before this particular development took place, it turned out that the excrement, you see it all does tie together, was essentially very low value, and the only issue was whether or not you or somebody else was going to remove it. And this was basically the obverse of property was, of course, pollution, and that, of course, is what we were talking about before. What happens is there's a sudden change in value with respect to these things. How is it going to be handled? When the change in value is discovered only midway through the transaction, you have a real bilateral monopoly problem in the event of full disclosure. In effect, this fellow could hold them up for a fortune. It turns out that that may be perfectly appropriate under the circumstances, but it will not be repeated, because once it turns out the way these things develop, you will get standard form contracts of one form or another, which will decide who owns that stuff and how the division of labor will take place. And it seems to me that what you want to do is to recognize that the breakdown in bargains in some cases are a function of novel circumstances that repetition will in large measure cure. How ought one then to treat it? I think in this particular case, the utilitarian comes out exactly the same way as the natural rights lawyer does. The particular transaction is not only a case of conversion, it also is a case of deliberate misrepresentation and fraud in the inception. And at that particular point, you could vitiate this thing on an ordinary contractual theory. In the long run, the problems will not exist, because since transactions cost low and there's lots of competitive circumstances, this particular waste material will probably be allocated by agreement to those who value it most. So there'll be a modest reduction in the price of hospital services in exchange for medical control over these things. So I don't think you ought to treat the novel case as anything else other than a situation where you discovered something was worthless and then all of a sudden it's worth a great deal, and you got the wrong set of contracts at time one, you get the right ones at time two. With respect to Carol, I think the point that I would want to make is, it's interesting that she talks about subjective preferences and then moves on, quite rightly, to a theory of propriety and status, which says that certain kinds of preferences are better than other kinds of preferences, and we have people who are in charge of certain kinds of things. So we have a form of virtue, as it were, as a constraint on preferences. Look at the kinds of things that are generated. She told us that it generated hierarchy with respect to sexual relationships. Men sort of owned and transferred women. She told us that it generated guilds and monopolies and franchises and taxes. It seems to me that once you get a classy idea like propriety and see that it produces some rather non-classy sorts of results, the response ought to be to say, gee, certain bad things come in very gilded cages, and what we ought to do is to just ignore the idea that we could tell something special, but because behind every claim of special propriety lies an ultimate special interest corrupt legislation. And I think the word special interest in its modern setting is perhaps a bit more descriptive of the world than special interest, which is implicit in a lot of the historical stuff. And I think it's a very striking advance of the idea that we should use government coercion to overcome bargaining breakdown. We ought not to use government coercion in order to impose our collective vision of the good on the world. And that means that there's a powerful tie between the natural rights thinkers and the Parisian thinkers against the authoritarian and Republican tradition. And I think going back to Ellen, that she's always attacking her friends instead of attacking her enemies. At least when she goes after the subjective utilitarians, she should be after the Republicans. And as regards Mr. Miller's presentation, it seems to me that there is actually an analogy there. Property on the good stuff, the part you want to take in, goes under the head of ownership. Property under the bad stuff, which are the things that you want to expel, goes under the heading of the police power. And this general system is that we want to encourage production and to be cautious about pollution. And I guess that starts at the earliest stages. So that essentially what we ought to do is to generalize the police power as a systematic effort to control the harms, not that exist at the oral stage, but at the anal stages of development.
Well, since I came after these two, and I'm speechless about the last, I don't have a great deal to say except in a quick response to Richard. I think it's quite true that the notion of property as propriety has a great many problems in it, and in fact, I talked about it as I did in order to illustrate some of those. I mean, it's a highly coercive system. I think, however, that Richard's always trying to slide out of the point that the utilitarian view always trumps the libertarian when push comes to shove. There's that coercive, there's that government coercion there whenever there's the bargaining breakdown, and that's the element I think that is different from the libertarian view. What I am interested in actually is whether the libertarian view doesn't have something like a notion of rights that is not dependent on the pie being larger, and if it does have such a notion of rights that doesn't depend on the pie being larger, does it then relate back to a notion of property as in some way being proper for individuals? I do think, as I said earlier, that the libertarian view seems to me as if it is much more confident about our ability to regulate our affairs without coercion. I want to mention one other thing historically about that, and that is that normally people who've had that kind of confidence in the ability of human beings to regulate their affairs without coercion, they don't have property either. This is a position that is for anarchy in the sense of no property. Property, it goes along with religion in some senses. Quite aside from that, there's a perfectionist view that some of us are so saved that we're above these notions of property. We don't have to have that stuff. That's for sinners. We are above the law. We are above property, and so forth. So that kind of confidence in one's own ability does sometimes lead in the direction of no property either. What interests me about the libertarian position is the very firm attachment to property, and at the same time, what strikes me as a very great optimism about the ability to have a property regime without coercion.
Let me put on my other hat, my social historical hat, and talk a little bit about some Vikings.
The man who's relevant.
I've never been accused of relevance. My Vikings, I kind of personalize them. My Vikings were people who, they settled Iceland in about 900, let's say, and they didn't find much there, but they set up a culture there. And one of the things they did was they didn't have a state, but they had an elaborate body of laws. They like to play around with laws and litigation, but they had no coercive mechanisms to enforce any judgment other than to kill the person who they got a judgment against, which is, of course, what they could always do anyway, because blood vengeance was a very positive value in the culture. But sometimes they decided to go to law first and then go kill the guy. Sometimes they decided to kill the guy first. One of the things that was kind of remarkable about this culture is it actually worked. So you have look, Iceland exists today with little immigration or emigration, so that the level of violence was not such, and this is a society that produces about zero surpluses. And there's the point. The one place where you can really have this nice old kind of stateless society is when you don't have a lot of surpluses. As soon as you start to get them, you get the state. And it's not the state that the poor and the downtrodden think up this idea. It's the people who have a little more than the person next to them. The state, as what, I get you upset?
No, I was glad to agree with you.
The state, I mean, if we want to go back to stateless times, which I'm willing to do, it seems like one of the concomitants of the primitive cultures that I've looked at, where you can get to true statelessness, is zero surpluses. As soon as you start to get accumulation, people start to be interested in protecting themselves against the right to exclude that Epstein is talking about doesn't come cost-free. The right to exclude is the state, and it's an expensive proposition. So factor that in when you want to conceive of your universe of libertarian splendor. I think a lot of you want to do a shortcut. You want to somehow maintain the present distribution of resources and how are you going to do that and get rid of the state? I think you forget, well, you can't, because once you have the present distribution of resources, you can hire private armies. But if you go back, if you don't have your present distribution of resources, but go back to a free-for-all, where everybody starts from ground zero, you will be the first people wishing there was a state.
Okay.
No,
those are very sober words, and I think, in effect, there's a vast difference between a libertarian position and an anarchic position. And the reason for that difference is that there are two forms of views about people if you're a libertarian. Carol emphasized the optimistic version. It's optimistic given the set of proper institutional constraints, remorselessly pessimistic in the absence of those particular restraints. What gave rise to the standard libertarian vision was an effort to try and figure out how you have centralized control which allowed you to escape the Hobbesian war of all against all. And if that's where you're coming from a view of undifferentiated social self-interest in which your libertarian theory is your first cut at trying to make private animosity or private greed or private selfishness work in long-term public advantage. And the great problem, of course, with modern libertarianism is once you put the state there to control the armies, it can do a lot of other things. And one of the other things it can do is it can redistribute rents and destroy them with a speed that is so astonishing that even its most ardent defenders think twice. What we've heard here from Professor Miller is, look, you don't want to go back to the status quo ante of no state. What you have to do is to try to develop that intermediate position where you could keep the monopoly of power in the hands of few and prevent the dissipation of the surplus through its excessive action. And what happens is when you get bad principles of eminent domain, it turns out that the government tends to fail in that second mission, even as it succeeds relatively well in the first one. And remember, with all the tirades we make here about zoning and rent control and minimum wages and so forth, notwithstanding all of this excrescence, see, back again, it turns out that we are far more successful at doing it than virtually any other major republic. And I guess in some sense that's a compliment to us and an indication of how perilous our situation is, even if our intellectual foundations seem, at least to some of us optimists, to be relatively secure.
If we have any contributions from the audience, go up to the microphones and take your turn.
Yeah, my name is Gary Lawson. Well, Richard, as you know, the first rule of libertarianism is always attack your friends. So here goes. Pareto's superiority can't possibly justify exceptions from a hardline property regime any more than it can justify the hardline property regime itself. Because all it takes is one crotchety old libertarian who says the thought of someone tiptoeing across my tundra is so grievous that nothing can possibly compensate me, just as it only takes one crotchety Marxist to say the thought of someone actually holding and exchanging private property is so grievous that nothing can compensate it. To knock a peroration as opposed to a preference maximization or Calder-Hicks regime down the drain.
Yeah.
Wrong?
Was that a comment or was that? Yeah. Let me give you what I think to be the answer to that question, which is not as happy an answer as I would like it to be, but better than any others. It's one thing to announce that such a person would in fact be in the position where he could do those things to you. And I think with respect to political organization generally, the more people you have, the more likely it is that the perverse fellow will come along, the more difficult it is to maintain the situation. The way in which most of us who've tried to work the situation from within is to try to use one or two saving devices, both of which are I think, subject. One is that push comes to shove, all these guys won't think that way. Because what you do is you ask them to announce their preferences at the time when their isolation from the tundra is going to come at the price of an equal probability distribution that they're going to die because somebody else will say you cannot rescue a person on your land because to commit a trespass is the ultimate good, and really stare at people hard and say, look, that guy may exist. Will he please stand up? And I guess at that point, even Gary Lawson would, I think, sit down. I think. I mean, I could be wrong. The other point, of course, is, and this is, a short speech, is the point of the veil of ignorance technology and all of its ambiguities is essentially to try to homogenize across persons in an effort to try to escape that dilemma by saying you don't know in advance whether you're going to be the crotchety fellow or otherwise. And that gets you into the question is that you so denature human beings that you have a veil to get you into a position where a person without any personal characteristics is designed to defend a system of subjectivism, which eventually comes out. And I think the reason why we do that is if you're smart enough to be behind that veil and you know both the benefits and the virtues of subjectivity, we will in effect decide to some extent that as an objective selves, what we do is we fear our subjective natures and praise them at the same time and therefore have a certain degree of ambivalence. But Gary, the right answer, which is none of those two above, is I don't think in the end at political theory anybody can come up with a theory which is going to be invulnerable against single isolated counterexamples. What you need is a much more, I hate to use the word empirical sense, which is if you give a vast run of cases and you try to get the consensus of view on the subjects, it turns out that the property rights plus the necessity exceptions is about as viable a first order condition that you can find, and that the ultimate defense in this sense is Hayekian, to sort of move back into your world, is that seems to get us as close to anything that we can get. And unless you could come up with something that looks a little bit better and a little bit more viable, we're going to stick with this on the grounds that it has a lot of the advantages that Carol started to talk about and avoids a lot of the disadvantages that Ellen's system, that is hard rights, no taxation, no government, no nothing, seems to lead us to. And in the end, I guess I am a formalist who increasingly thinks that the customary and cultural basis for these things is a lot stronger than one would have otherwise had thought. What one tries to do is use the formality to explicate the custom, and then the custom to understand the formality. And by going back and forth between the two of them, you end up a cross between the formal Richard Epstein of some years ago, the formal welfare economist, somebody like Bob, for example, who always starts with practical norms and then always comes up with general theories. And I think the convergence is powerful enough that one won't trouble. Just to give you one example, the Ellickson rules that you see in Shasta County are my common law rules of tort with animals, devised, I might add, from completely different grounds, and they're much closer than the common law rules that have come out from the judges.
Reflective equilibrium.
Yeah, that's not a bad term.
Can I stick an oar in on this too? Gary, I don't know if you want to go back to the microphone or not, but I wanted to add something to this too. Richard started a few minutes ago saying that the problem of modern libertarians is all of this state stuff, and I don't think that's it at all. The first problem is all those necessity problems, transaction costs, holdouts when there are economies of scale, and all the rest of it. And the whatever state problems there are, they come later when we agree that there's going to be some coercive system that gets us over that, or perhaps some coercive system. And the problem is, of course, that if you allow those difficulties to continue, the holdout and the necessity situation and all the rest of it, we're going to impoverish ourselves if we stick with a fixed property regime where the holdout can go on holding out forever. Now, we got these state mechanisms for getting over it. There are lots of other things too, and I guess that's what you were getting at in the later part of what you were saying. My own view is that if you say the holdout should be able to hold out forever, you're not talking preference satisfaction anymore. You're not talking utility, which I think you want, Richard. You're rather talking something like libertarian. You're talking about those rights that are just there. But it's not in order to make us all wealthier. It's because something else is at stake. There are lots of ways to get over those problems, and they don't have to do with coercive systems necessarily. They're customary things. Now, you might think that custom is also sort of coercive. All those people gossiping about you that, again, Bob talks about. The exclusion from things that you would, the multiple fronts that you're involved in your neighbors with, the things that you can't do now because they all hate you. Those things will keep you in line, too. They're not status. They're sort of customary practices that develop around neighborhoods, and not status. Whether they're coercive or not, well, I'm not sure about that. But there are some ways out of those problems, I think, that don't necessarily take us straight to the line of legislatures seeking rents all the time.
Other questions?
There's not a microphone, but I'll try to speak loudly. Burke has a quote, which I don't remember exactly, about the origins of property and other things remaining hidden. And I think that the role of language, and perhaps of the academic roles here, is to conceal rather than to reveal the origins, because society functions perhaps not by revealing what it is doing, but by concealing it and maintaining a peace. Gluckman has a concept of people within the legal system having mutually contradictory ideas about what's going on, and that's one of the cements that makes a system work. Similarly, systems work because people they turn away from what they're doing or from the effort to understand, because the understanding perhaps would tear it apart. They have, in fact, a pre-existing system in which they find themselves, in which they articulate. Seeing that to be the case, aren't you involved perhaps in an endeavor which simply, it has an uncertainty principle built into it, and it can't actually work? All it can do is provide partial tools to operate a system, but it can never provide a satisfactory answer.
Let me try and answer that one. To half agree and half disagree. There are basically two ways that one could work social contract theory, which seems to be inevitably what we've returned to again. One is to try and start from a situation of atomistic individuals and figure out how by consensual or coerced transactions you could come up with a viable set of outcomes that meets some standard of preference, satisfaction, utility, justice, or whatever. And I think that's a much harder task than the second question, which you put us, is given where we are today, what can we do to maintain the body politic and not have it run aground? where you have a whole set of network of conventions and so forth. And I think that second task is essentially the one that faces us from where we go here, and in that sense, everyone is an incrementalist. But what happens about it is that everybody's very uneasy about the legitimacy of the starting point as the grounds for subsequent legitimation, unless you can do the first thing. And so therefore, we are constantly tossed into that tension. And, libertarians don't escape this any more than anybody else, because, the problem of America belonging to the Indians under a first possession rule is something which has an enormous amount of power. And therefore, we are constantly forced to sort of make second-best adjustments in the face of an inability to articulate perfectly comprehensive first-best principles. But what you can do if you take the hard line is you learn more and more about subsystems. You become, on balance, somewhat more confident about the hunches that you would have generally, and that means when you get to zoning and rent control and minimum wages and regulation and common pool and taxation, you can do better if you have your state of nature theory in reasonably good array than you could do if you never bothered to think about it at all. But that doesn't mean you could ever ignore your set of problems, which is given that we are where we are, you cannot ignore transition problems in the relentless pursuit of as it were, an optimal first theory. So I agree with you, but I don't think that the agreement with you goes so far as to say that we ought to banish the more abstract inquiry simply to worry about the here and now.
I didn't want to banish the inquiry. What I wanted to point out was that two of the panelists were approaching it from a point of view which was historical or social in a sense, not anthropological, and therefore they worked with pre-existing systems as examples, whereas you, the economists, as it were proceeding with a model.
No, that's not right.
They started with an event which perhaps was hidden, from which they tried to elucidate. You started from a model which tried to approach reality. I'm suggesting you're coming from different ends academically, but neither of you will quite get there. Not that you should abandon it, but there are weaknesses and strengths in the different approaches, and that's what I'm trying to
and I agree with that. But on the other hand, if you recall, I said that at the beginning I started with an austere model to show you what it led to. But all of the counterexamples I gave were deliberately from very ancient rules of the necessity in the trespass cases, the privilege in the defamation cases, the live and let live rules, precisely to show that the common law system, in effect, had the necessity exception built into it at the front end. It was not a question of some later incrustation of the welfare state. And that's the point of Carroll's argument, is that early on, the pristine Lawson view of the world had been abandoned by people who had no particular ideological temptations, because what they did is they saw transactional horrors. What I was trying to do is to figure out how both halves of that system made sense. So it was an effort to try to apply analytical tools to clarify a lot of historical stuff. Indeed, I began law, and I hate to tell you, as a Romanist. First thing I ever studied in law school was Roman law, because I was not trained in this particular country. And I'm very heavy into the history, but I think that for exposition points, I chose one way and then used historical examples. But I don't think that there's a fundamental disagreement with us on the fact that if you ignore the way in which rules endure, you will never be able to make an adequate statement of theory.
I want to disagree with that, too.
Well, go.
Well, Richard, again, I don't quite agree with you about that. You start out with the notion of getting your state of nature in order, the atomistic of individuals, and then they're in this state and they get out of it in various ways. You can look at the world in very different lenses, and that's what I was trying to do with the historical examples of that. Nobody's in a state of nature. Nobody really believes that. Even Locke didn't believe it. He said so. He said, I don't believe it.
And then he proceeded to talk about it.
And then he proceeded to talk about it, but it's an analytic ploy. And you can look at, you can go from a different basis. You can say everybody's in a family in some way. Now, how's a family organized? A family is organized more or less hierarchically. At least there are some people who have more authority than others. And if you think that that's the nature of the way people live, then you might think, we can't give up on that authority. Indeed, there's some historians who talk about the development of property systems. The 18th century view about property with Adam Smith and the Scottish Enlightenment and that crowd, the great interest in that was because it looked as if individuals could own property and they could buy and sell and trade and all the rest of it, and you didn't have to have a hierarchy to run things for you. That was the really political message of all of that. The earlier view was that we cannot do without hierarchy. We must have hierarchy to keep ourselves going. And I was only using family as a possible example of where that notion would come from.
Non-market as well as hierarchy.
All I want to say is that if you start with that different set of views about what's important, you're going to come up with a different view about what property is.
Let me try to answer that particular. As I think there's some truth to what Carol says, but again, it's a slightly different nuance. The reason why there are two views to the social contract theory. The hardest thing to do is to take the Hobbesian assumptions about individual self-interest and see if you could figure out through voluntary exchange or coercive mechanisms how you end up with a political system. And I think Gary's examples to some extent suggest that you're going to fail. Nobody's going to be able to come out with something which meets the Pareto superior test at the level of precision that we would like to have. The way in which some people get around them is to then go back and to introduce a system based on biology or tradition of interdependent utility functions, which essentially gets rid of the atomism. It turns out I care about people in my family, so that what you do is you get the state that emerges out of family, out of clan, out of tribe, and so forth. And it seems to me that what happens is now you take the model and you relax the factual assumptions, and it turns out the bargains and the exchanges and the coercion has a great deal more going for it. And I think what you have to do is to start with the austere model, see that it breaks down, then take the less austere model and see the way in which it picks up the pieces. And I don't see that there's any particular contradiction about the fact. Indeed, one of the central lessons you learn from that is that the informal mechanisms that keep a family going will not work when the bonds of genetic interactions are sufficiently weak that the atomistic assumptions start to dominate. And so that what you have to do is to resist Mario Cuomo's 1984 speech, which says that the state is just one large happy family, because it turns out it isn't. And therefore the modes of connection are vastly different. And what you then do is come up with the following set of propositions, which is that the common law type property rights of individual possession, use, and disposition that I described are most powerful in situations in which genetic separation and individualism work, and least attractive in circumstances where they're interdependent utility functions. But that's just a longer talk that one gives, and I think in the end, there isn't really a fundamental disagreement between us. It's just the question is that you have to sort of work out the self-interest model, then modify it, and as you start to do that, it will quickly come to pass that a world of autonomy without forced exchanges is not viable, either in the family setting for a whole variety of personal reasons or in the public setting. And that's the great thorn of the libertarian situation. Forced exchanges come in too early, too forceful, and too insistent for one to say that autonomy itself is a principle which organizes any principle of any social system, whether based on objective or subjective satisfactions, custom, tradition, or whatever.
My name is Bill Laffer. My question is for Professor Miller concerning the proposition that as soon as surplus arises, the state emerges. I wanted to ask him which of two possible causal mechanisms is the one that accounts for this. Is it a matter of as soon as surplus arises, there arises a demand on the part of individual property holders for a mechanism for protecting their surplus? Or is it that as soon as a surplus arises, a state emerges as an organized attempt to appropriate as much as possible of that surplus? Or both? I mean, it may be a matter of selling, offering to sell protection, and then with an implied threat to be that against which you need protection if you don't make the purchase. But what did you have in mind?
Now you're going to make me be scholarly, and that's just what I don't want to be.
I apologize.
Yeah, you're walking away already. Oh, okay. I don't think these things are that there's a kind of grand deterministic causal mechanism which produces states of the same sort in every instance. That there's quite a variation over how states arise in different historical settings at different particular instances. The type of agriculture or the type of economy that's the underlying basis for the wealth production would have some kind of some say in how it goes about. And your question is a very good one. I would think that both ways could be found in the historical record. The ones I'm familiar with proceed in kind of, when we're talking about primitive states, we're talking about real primitive things. We're talking about meetings of people maybe meeting regularly rather than irregularly. We're talking about the finally some people who decide that when they make a legal decision settling their own affairs, that they can bind third parties. We're talking about a slow extension of something that we will recognize as jurisdiction. and the profits of, let's say, enforcing judgments, or the profits of being able to settle other people's disputes. So one of the ways you first see the state kind of arise, or at least one of the ways that the state funds itself when it starts to arise, is precisely in the dispute processing area, where they manage to take a cut on everybody else's troubles. Now, the only point where there's still enough people who can build enough forces, maintain enough people around them, so that they can actually impose their will on others, means that they are able to at least show a sufficient amount of, let's say, harvest, or at least have a way of hauling in sufficient expropriations from other people's harvest to be able to feed retainers. And this is at the very simple level that state formation takes place. But you know what, and this is the step back, and you asked a question that is the subject, could be the subject of about 3 courses, so I'm going to be rather random in my approach. The other thing is that states arose. It's like one of these settings where, what was the first state? There never was a first one. Everybody always had a model of a state before them. We don't have any records of people who formed states without models of states before them. And in the West, the Roman Empire was always a model by which the medieval states tried to, when somebody got a little power, he tried to pretend to be one of 2 things, either a Hebrew king or a Roman emperor. And he had those examples before him because he read about them, or at least had priests tell him about them. And so he tried to imitate people. And what he saw in those when he saw in Rome and what he saw in the Hebraic system was systems of taxation, systems of let's say, skimming production from other people. But people were trying to desperately imitate other models, and they could only do it feebly, but they held that up as a goal. Now so we have the interference of other models. You don't get a pristine case of the state just arising from Western European examples. That's not a very good answer, and that's why I'm being scholarly, because I'm going to have to say on the one hand there's this, and on the other hand there's that, and I'm not going to be able to be very specific. But you can see in my little Icelandic record, what you can start to see is that without the state, there's a rough egalitarian balance. When somebody gets too big, it's kind of like the Wild West syndrome. People go looking for fights with that person because you get honor by knocking that person down. So what there is a leveling mechanism. Anytime anybody gets a little too big, he gets knocked back. And for instance, one of the classic examples is of somebody who manages to have good harvests too many times. There's a case, there's a story from a little example from Africa in the ethnographic record. Somebody says if somebody catches 1 fish, that shows a little skill. He catches, or luck, I guess it was the first time. If he catches 2 fish, it shows skill. If he catches 3 fish, it's witchcraft. And what that means is he'll be killed. So what you have is in these communities, you have a communal, it's not the war of all against all, it's community norms being enforced against people who are starting to get a little too big for their britches, and they knock them back down to size. Now what happens is at a certain level, at some point, some people are actually able to prevent or to actually be 1 step ahead of the leveling mechanism and to anticipate it and to make sure they don't get knocked down. Now then they have the problem of being able to pass that on to the next generation, but that's a problem, and it takes time for that to work out. The one thing that these people... Enough! It's my turn!
No, it's their turn.
I'm not going to give the whole course.
It's my turn. I just say I know that Richard Epstein is very concerned about leaving in a minute because he has to catch a plane in about 40 minutes, I think. But the question that arose was one of the few cases in which the subject of property was discussed in Adam Smith's Wealth of Nations, where he said that not much in the way of property would be accumulated until the state was there to protect it, because the people wouldn't work to accumulate this property if it could be stolen from them. But on the other hand, if there wasn't much in the way of property accumulated, then the state wouldn't really be able to arise, because the state itself needed to consume resources to exist. And just very briefly, if Richard, you don't mind, you run out at any time. It's a great mystery to me, has been in the subject that I have really been studying, is why in the history of economics the subject of property has not really arisen, but it did not really arise very much until the mid-19th century when the socialists attacked property. The mystery is that before that the classical economists had not defended it. It had not arisen in the writings of Adam Smith and Ricardo and Malthus and James Mill. And the reason for that was because it was taken for granted. It had been established, as it were, intellectually. I think it was Hume who said, David Hume, who said that there were three fundamental laws of justice: the stability of possession, translation by consent, and performance of promises. And this simply was not intellectually in dispute at the time of Adam Smith and of the early classical economists. Then came the vehement socialist attack in the mid-19th century, and there was no real defense. And you see the subject really being addressed for the first time by John Stuart Mill in Principles of Political Economy, which first came out in 1848, the year of the Communist Manifesto. And he said, well, we're just going to have to wait and see what happens when he said he figured that people probably would work harder if there wasn't private property, because they would seek to emulate one another and so on, and there would be this glorious socialist future. But he was sort of open-minded about it. And then the real test and the interesting case comes with Alfred Marshall in 1890 with his Principles of Economics, the very key textbook. He was a key teacher of Keynes and so on, and he came up with the supply and demand curves for the first time. And he has almost nothing on property at all in this book, but what he does say is of great interest. He says that the need for private property goes no deeper than human nature. And human nature, as we know, has been changing rapidly in the past 50 years. There was an assumption that human nature was going to change and that private property would not be needed. This was then put to the test in the Soviet Union. They tried to change human nature and they failed, and that's why we're here discussing, and that's why property is back on the agenda today. Thank you very much.